If you're thinking about signing the deed to your house over to your kids right now, please stop. There is a very specific estate planning trap hiding inside that generous act that has financially destroyed perfectly prepared retirees, and most people don't realize it exists until the IRS sends a letter or a nursing home hands them a denial. My name is David, and for over a decade and a half, I've helped seniors protect what they spent a lifetime building. In the next few minutes, I'm going to walk you through the exact scenario that triggers this nightmare, why your good intentions can actually create a massive tax bill for your children, and the safer alternative that keeps you in control, protects your home from a Medicaid spend down, and still allows you to pass the property to your family without losing everything. Let's start with a story that I see play out at least 3 or 4 times a year, and it always starts the same way. A widow in her late 70s sits down in her kitchen, calls her kids over, and says, "I want to make things easy for you. I don't want you to deal with probate. Let's just put the house in your name now." And so they go to a local attorney, or sometimes they just prepare a quitclaim deed themselves online, and they transfer the house to the adult children. On paper, it looks like a smart move. It feels like you're getting your affairs in order. You think you're avoiding the court system, avoiding delays, and giving your kids an inheritance early. But what no one explains at that kitchen table is that by doing this, you have just handed your children an invisible tax trap that will cost them tens of thousands of dollars the moment they sell that house after you pass away. Here's how the trap actually works, and I want you to listen carefully because the numbers involved are often staggering. When you own a home and you live in it for at least 2 of the 5 years before you sell it, the IRS gives you something called the capital gains exclusion on your primary residence. As of today, that means if you are single, you can exclude up to $250,000 of profit from taxation. If you are married, that number jumps to $500,000. So let's say you bought your home 30 years ago for $80,000. And today it is worth $400,000. If you sell that house while you are still the legal owner, you could walk away with that entire profit and pay exactly $0 in federal capital gains tax. The home is your biggest asset, and the tax code actually protects you. Now here is where the trap snaps shut. The moment you gift that deed to your children while you are still alive, you are also gifting them your tax basis. In simple terms, the cost basis is the original purchase price of the home. So if you bought the house for $80,000 and you hand the deed to your son, he now legally owns a house worth $400,000, but his cost basis in the eyes of the IRS is still your $80,000. You continue to live in the house for another 10 years, and then you pass away peacefully. Your son now wants to sell the property. It has appreciated even more. Let's say it is now worth $450,000. Because you gifted the house to him while you were alive, he does not get a step up in basis. He sells the property and realizes a taxable gain of $370,000. Depending on his tax bracket, he could be staring at a capital gains tax bill approaching $70,000 or more. That money is gone forever. And the tragedy is that this entire tax burden could have been completely avoided if the house had simply remained in your name until your passing. Let me pause here and acknowledge something because I know what some of you are thinking. You're thinking, "David, I'm not worried about my kids paying taxes. I just want to protect the house from the nursing home. I want to make sure Medicaid doesn't take it." I hear you. That fear is real. And it is exactly that fear that pushes seniors into making the gift transfer without understanding the 5-year look-back rule. The government is very smart. They know that people would simply give away everything the month before entering a nursing home to qualify for long-term care benefits. So they created a look-back period. In most states, when you apply for Medicaid, the caseworker is going to examine every financial transaction you made over the last 5 years or 60 months. If they see that you transferred a $400,000 house to your children for no money, that is considered an improper transfer of assets. It doesn't matter that you were healthy at the time. It doesn't matter that you did it with good intentions. Medicaid will impose a penalty period where they will not pay for your care, even if you have no other money left. The math on this penalty is brutal. They take the value of the house you transferred and divide it by the average monthly cost of a nursing home in your state. Let's say that number is $10,000 a month. If you gave away a $400,000 house, they will calculate a 40-month penalty period. That is, over 3 years where you are completely ineligible for nursing home coverage. And here's the cruel twist. The penalty clock doesn't start when you made the gift. It starts when you have exhausted your other assets, entered a nursing home, and applied for benefits. So you are physically in a facility, you have no money to pay for it, and Medicaid says we will not cover you for 3 years because of that generous act you did 6 years ago. Your children would then be forced to sell the house at a loss, pay the huge capital gains tax we just discussed, and use the remaining proceeds to pay for your care, all while under unimaginable emotional stress. This is not a theoretical warning. I have consoled families who had to liquidate everything, and the adult children ended up with nothing but resentment, not toward their parents, but toward a system that they didn't understand. The government program designed to be a safety net became a trap door because of a simple deed transfer done years too early. So at this point, you might be asking, if I can't just sign the house over, how do I protect it? This is the part of the video where you want to lean in, because I'm going to give you the tool that professional estate planners use to solve both the tax problem and the nursing home protection problem in one clean structure. It's called an irrevocable trust, and more specifically, an irrevocable Medicaid asset protection trust. I know the word irrevocable scares people. It sounds like you are losing control. But let me explain exactly what it means in plain English and why it is almost always the superior option to a direct gift. When you place your home into a properly drafted irrevocable trust, you are technically removing it from your personal ownership. You no longer own it in your individual name. So after the 5-year look-back period has passed, it is not a countable asset for Medicaid eligibility. But unlike giving the house directly to your children, you retain the right to live in that house for the rest of your life. You still pay the property taxes. You still get the homestead exemption. You still control the maintenance. You do not need your children's permission to paint the walls or replace the roof. In legal terms, you retain a life estate interest. That means the house is your home until you pass away. Now, what happens when you do pass away? This is where the trust shines compared to the outright gift. Because the property is moving to your children through an inheritance mechanism, they will receive what is called a step-up in basis. The cost basis of that home is updated to the fair market value on the date of your death. Let's go back to that $80,000 purchase price. If the house is worth $450,000 on the day you pass, your children inherit it with a brand new cost basis of $450,000. They can turn around and sell it the very next week, and the taxable gain is zero. You have just saved your family nearly $70,000 in taxes, and you have successfully navigated around the Medicaid look-back period as long as the 5-year window was satisfied. I want to be very clear here, because I am not an attorney and this is not legal advice. This is education. Setting up an irrevocable trust is not a do-it-yourself project. You cannot download a form from the internet and hope it works. These trusts must be drafted by an experienced elder law attorney in your state. They need to include very specific language regarding income rights, substitute assets, and powers of appointment. If you make a mistake, the trust can be deemed defective and the house can be pulled right back into the probate process or the countable asset pool. But when done correctly, it is the gold standard. The cost of setting up this trust, which might be a few $1,000s, is often less than 2 months of nursing home care, and it is certainly less than the tax bill your kids would face without it. Now, let me address one more scenario because I know some of you have already transferred the house. You're watching this video and your heart is sinking. You signed the deed over to your kids 2 years ago. Is it too late? Not necessarily. You need to act quickly, but you have options. A good elder law attorney may be able to reverse the transfer by deeding the property back to you. The IRS has a rule that if a gift is returned to the donor prior to the donor's death, it can sometimes be treated as if the gift never happened, depending on the terms and the timing. However, this must be done carefully because transferring it back could create a second taxable gift from your children to you, which is another mess entirely. And if you are already in declining health, reversing a gift can look like purposeful manipulation to a Medicaid caseworker, potentially triggering a fraud investigation. The moral of the story is that time is your enemy. If you are healthy and active right now, today is the day to fix this. Do not wait until a diagnosis forces your hand. Beyond the tax bases and the nursing home rules, there is a third danger with gifting the house that nobody talks about, and it is the loss of control. When you put your child's name on the deed, that house becomes their legal asset. If your child gets divorced, their ex-spouse could claim a portion of your home in the divorce settlement. If your child has a business failure or gets into a serious car accident and is sued, a judgment lien can be slapped onto your house. If your child has creditor problems or files for bankruptcy, the bankruptcy trustee can force the sale of your house to satisfy debts. You could be an innocent 85-year-old woman who just wanted to make things easy, and you find yourself sitting at a kitchen table with a stranger in a suit, explaining that you have 60 days to vacate the property because your son co-signed a business loan that went bad. That nightmare is real, and it happens far more often than most families want to believe. With the irrevocable trust, that house is protected from your children's creditors, their spouses, and their financial mistakes. It remains a sanctuary for you, and eventually, a protected inheritance for them. Let's talk about the probate fear, because that is usually the main motivation for gifting the deed. You don't want your kids tied up in court for a year. That's completely valid. Probate can be slow and expensive, but signing over the deed is not the only way to avoid probate. The irrevocable trust avoids probate entirely. The house is already owned by the trust, and upon your death, the successor trustee, usually the adult child you trust most, simply follows the instructions you laid out. They can sell the house or distribute it to the siblings without ever setting foot in a probate courtroom. It is private, efficient, and immediate. So, the very goal you wanted to achieve by gifting the house, avoiding probate, is accomplished while also dodging the capital gains bomb and the nursing home penalty. I also want to mention something that often goes overlooked regarding the sale of the home while you are still alive. Life changes. You might decide at 82 that the stairs are too much, and you want to downsize into a single-story condo in a warmer climate. If you have already gifted the house to your children, you cannot simply sell it and use the money yourself. It's their house. They have to sell it, and if they give you the proceeds, that is technically a gift from them to you, which could affect their lifetime estate tax exemption limits. It becomes a circular mess of tax filings. When the house is in an irrevocable trust, the trust document can include a provision that allows the trustee to sell the house and buy a replacement property for you. You can move, and the asset protection follows you to the new condo. That flexibility is priceless as you age, because we know that what you want at 75 might be very different from what you need at 85. As we start to wrap this up, I want you to walk away with 3 clear action items. Number 1, do not sign any deed over to your children tomorrow morning. Just pause. The tax consequences and the government penalty triggers are real, and the look-back clock is not forgiving. Number 2, if you have already made the transfer and you are still healthy, schedule a consultation with a certified elder law attorney in your state immediately. Ask them specifically about the step-up in basis issue and whether a deed reversal or a trust restructure makes sense for your specific numbers. Number 3, if you haven't transferred the house yet, but you know you want to protect it, have the conversation about an irrevocable asset protection trust. Ask the attorney to explain the difference between the grantor trust rules and the income tax rules so you understand that you can still claim the property tax benefits while you're alive. A great question to ask in that meeting is simply this: will my kids owe capital gains tax when they sell this property after I'm gone? If the answer is anything but a confident no with an explanation of step up in basis, you need a second opinion. Your home represents not just money, but memories. It's the smell of Sunday dinners, the creak of the back porch, the sound of grandchildren playing in the yard. Protecting it shouldn't feel like a gamble. You worked too hard for too many decades to see that legacy eroded by a tax bill or a nursing home penalty that could have been completely avoided with a single afternoon of proper planning. The difference between a deed transfer and a trust is not just legal paper. It is the difference between handing your kids a financial burden and handing them a secure, tax-free inheritance. If this information opened your eyes to a risk you hadn't considered, please take a second to hit the like button. It helps other seniors and their families find this video so they don't fall into the same trap. And if you want to stay informed on the rules that could change your retirement security, I invite you to subscribe to the channel and tap the bell for future updates. I'd also love to hear from you in the comments. Have you already transferred a deed in your family, or are you considering it? Share your experience below so we can all learn from each other. I read as many comments as I can, and knowing your stories helps me make better videos for you. Thank you for spending this time with me, and I'll see you in the next one.